Dear learners, in our previous lecture, we discussed about the European Convention on Human Rights, and we discussed the background under which it was adopted. The never again spirit was behind it because people in Europe, the pacifist sentiments were very high after the Second World War. So that is why the people wanted that it should not happen again. So that spirit was behind this particular convention. After that, we also discussed what are the things that are there in the preamble of the convention, what are the things that have been emphasized, and we found that the UDHR has been cited. And after that, we also discussed some provisions of the convention. So, as amended by significant provisions, we are going to discuss today, and I'm going to take up from the point I left yesterday. So, as amended by Protocol 11, the convention consists of three parts. The main rights and freedoms are contained in Section 1, which consists of Article 2 to 18. Then Section 2, Articles 19 to 51, sets up the court and its rules of operation. And then Section 3, that is, contains Section 3, that contains various concluding provisions. So yesterday we discussed about the Article 1, that is obligation to respect human rights. The high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this convention. And after that we discussed that right to life is very important. That is, of course, the right to life is a universal right. So right to life, everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. So, that we discussed. But now you will find that the abolition of death penalty is there. So that is why, this Article 2 should be understood in the context of the abolition of death penalty as well. Article 3, a prohibition of torture. No one shall be subjected to torture or to inhuman or degrading treatment or punishment, that we have already discussed. Article 4, that is talk about prohibition of slavery and forced labor. Article 5, that is right to liberty and security. Everyone has the right to liberty and security of person. No one shall be deprived of his liberty save in the following cases and in accordance with a procedure prescribed by law. And what are these things? The lawful detention of a person after conviction by a competent court. So then personal liberty can be curtailed. Then the lawful arrest or detention of a person for non-compliance with the lawful order of a court or in order to secure the fulfillment of any obligation prescribed by law. Again, so it is very much clear. Again, if a person is not following the order of the court, then ultimately his or her personal liberty can be curtailed. The lawful arrest or detention of a person effected for the purpose of bringing him before the competent legal authority on a reasonable suspicion of having committed an offense, or when it is reasonably considered necessary to prevent his committing an offense or fleeing after having done so. So, if the suspicion is that the particular person has committed a crime, then the person can be detained or arrested. Or if there is a suspicion or apprehension that the person, if he is free, or he or she may commit a crime, so under that kind of situation, the person can be lawfully detained or arrested. Again, you see, this is important, that the detention of a minor by lawful order for the purpose of educational supervision, or his lawful detention for the purpose of bringing him before the competent legal authority. So, the educational supervision has been mentioned. You see, again, this is important, for which a minor can be brought before the court and he can be detained for that particular purpose. So that kind of detention can be considered as a positive detention, where because the educational supervision of the child is important. the lawful detention of persons for the prevention of the spreading of infectious diseases of persons of unsound mind, alcoholics or drug addicts or vagrants. Again, you see that if a person is suffering from contagious disease and he's or she is spreading it, or if there is any kind of danger of spreading the disease, then person can be, of course, a lawful ground, or lawful, you can say that the curtailment of liberty. The lawful or arrest or detention of a person to prevent his effecting an unauthorized entry into the country, or of a person against whom action is being taken with a view to deportation or extradition. So we can find that Europe these days, if you see the narrative, there is a narrative very dominant in political spaces, and that is against migration. So when the migrants are there, migrants means there are people who may go with valid visa and passport, but there are people who are trying to enter into European countries without any kind of permission. So they are not following the due process of law, or the process by which they have to enter into a country. So under those kind of circumstances, you can say it is an illegal entry. So if the illegal entry or migration is there, then the person can be arrested, detained for the purpose of deportation. Or if a person has committed crime and enter into European country, then of course for the extradition, for that purpose, which is a very important principle of the international law. Article 6, right to fair trial. In the determination of his civil rights and obligations, or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. So again, this is important legal right, that the right to have fair trial, and that too by the independent and impartial tribunal. Judgment shall be pronounced publicly. It is public trial. This is very, very important. Judgment shall be pronounced publicly, but the press and public may be excluded from all or part of the trial in the interest of morals, public order, or national security in a democratic society, where the interest of juveniles or the protection of the private life of the parties so require, or to the extent strictly necessary in the opinion of the court, in special circumstances where publicity would prejudice the interest of justice. So, some exceptions have been already mentioned. I wanted to point out that in the name of national security and public order, you will find most of the time the states try to infringe upon the rights of the people. So, though, if the public trial is there and the public pronouncement of judgment is there, that is in the better interest of the human rights. Because you see that a state as organizer of violence, or a state sometime itself is violating the rights of the people. And if the people are going to the court, and under those kind of circumstances, in the name of national security, what happens? For example, if the state is levying charges against a person, then an individual is fighting against the might of the state. Under that kind of circumstances, these days there is a lot of debate and a discussion, deliberations among the human rights activists and the scholars, that in the name of national security or public order, in many cases it has been found that the rights of the accused, the rights of the people who are being tried, they have been violated. So that point is, of course, the security centric delivery system that most of the time is leading to the violation of the rights of many people. Article 7, no punishment without law. No one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national or international law at the time when it was committed. No, nor shall a heavier penalty be imposed than the one that was applicable at the time the criminal offense was committed. It means that the prevailing law will be operating when a person is being tried for any kind of crime. So it means a new law, if that is framed, and the person had committed a crime when the old law was existing, so the person cannot be tried according to the new law. So that is important. Article 8, right to respect for private and family life. Again, this is important. Right to privacy is a very important right recognized under the Western liberal tradition of human rights. And that is, universal right, of course. So, what are these rights? Everyone has the right to respect for his private family life, his home, and his correspondence. Uh, what is being mentioned, that family life and the private space. The private space should not be invaded either by the state agencies or by other members of the society. At the same time, you'll find the family life should not be disturbed. Means that is again important. And thirdly, which is very important to mention here, and that is from his home and his correspondence. So the home is a personal space, for example. Family life is a personal space. Similarly, you will find the correspondence. These days, because of hacking, or because of the internet, or any kind of communication that the people are maintaining, it can be hacked and that can be made public. So that space, even the space in the internet that you are operating, that is also your personal and private space. Whether you are handling a social website or social media, whatever. So you have already got your own personal or private space that should not be invaded by people without your permission. That has been emphasized here. Even the letters that are being sent, or the mails that are being sent, no one should read. And that's why you'll find many all these portals, those who are operating it, they say that the privacy is maintained. So the privacy clause you'll find everywhere. There shall be no interference by a public authority with the exercise of this right, except such as in accordance with the law and is necessary in democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. These are the exceptions under which you see that the right to privacy can be curtailed, or that can be compromised, because again national security is being invoked. You will find many other things are. So these are the reasonable restrictions that have been enlisted here. Article 9 is talking about the freedom of thought, conscience, and religion. Everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in worship, teaching, practice, and observance. You will find that freedom of conscience is being recognized, which is, of course, mentioned in the Universal Declaration of Human Rights and all the international instruments of human rights. Wherever you will find that right to freedom of conscience is discussed, it is emphasized. Article 10, freedom of expression. Again, very important for all the democratic societies. So everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing of broadcasting, television, or cinema enterprises. So, this is again in the individual capacity. Somebody can have his own opinion, he can freely express it, and there should not be any kind of restriction. But at the same time, certification is needed, or licensing is needed for broadcasting, television, or cinema enterprises. Article 11, freedom of assembly and association. Everyone has the right to freedom of peaceful assembly and to freedom of association with others. This is again, peaceful assembly is recognized everywhere. No restriction shall be placed on the exercise of these rights other than such as are prescribed by law and are necessary in a democratic society in the interest of national security or public safety. Again, that is mean for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedom of others. So you can note that what is being emphasized, that the reasonable restrictions, they have been already mentioned in the convention. What can be the reasonable restrictions, but at the same time democratic society is being emphasized everywhere. It means the rights that are sacrosanct in democracies are, of course, right to freedom of expression, right to hold an opinion, And also, if you have an opinion, you can express it freely. There should not be any kind of restriction. But at the same time, it doesn't mean that the ideas, that are dangerous, the ideas, which are inciting for violence and all, that can be allowed to be there. So that way, some reasonable restrictions can be imposed if national security or the morals or the public order is in danger. Article 12, right to marry. Men and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. So it means, what is important to mention here, that right to marry, men and women of marriageable age have been, mentioned here. But these days you'll find that a lot of debate and discussion is there on the rights of sexual minorities, means transgender, bisexual, lesbian, and the gays. So the debate and discussion is that they should also have these rights. And many countries you'll find they have already legalized it. The marriage between the same sex or the same sex marriage. All these have been legalized by many countries. So in that sense, you can see that when the men and women, only two gender is being identified here. But there are many genders that the people are pointing out, and that's why you'll find the movements, they are already there in the all countries. And what is being emphasized, that sexual minorities should be given their due, no, their due, and that is the right to marry. If they want to marry, that should be recognized and that should be accepted. Article 13, right to an effective remedy. Everyone whose rights and freedoms are set forth in this convention are violated shall have an effective remedy before a national authority, notwithstanding that the violation has been committed by persons acting in an official capacity. So, again, you see effective remedy. For example, in our own constitution, you have under fundamental right, Article 32. So, that is a judicial remedy. Article 14, prohibition of discrimination. We have already discussed that, the principle of non-discrimination and equality is the integral part of all human rights instrument today. So here also it is being emphasized, that is prohibition of discrimination. The enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any ground. So such as sex, race, color, language, religion, political or other opinion, national or social origin, association with a national minority, or property, birth, or other status. Article 17, prohibition of abuse of right. Nothing in this convention may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at destruction of any of the rights and freedom set forth herein or at their limitation to a greater extent than is provided for in the convention. So again, you see restrictions and all, they are justified in this sense. After discussing these rights, we are coming to the point, that is implementation mechanism. The European Convention on Human Rights effectiveness hinges on its robust implementation mechanism, ensuring rights enshrined in the convention translate into reality for individuals. Here is breakdown of the key elements. What are the implementation mechanism that we are going to see? Because if you have very good provisions, the catalog of right is vast, but if they are not being implemented, then they become golden letters written over there without any kind of legal sanction. So here what is there? That first of all, the implementation mechanism we are going to examine, and number one is individual petition right. While discussing ICCPR, we found that the individual petition system is part of what we call optional protocol. So the countries may be the party to ICCPR, but they may say that we are not accepting individual petition system, and that you will find in most of the cases it has been done. Most of the countries, or majority of the countries, they have not accepted individual petition system. But here you will find individuals within member states can submit complaints directly to European Court of Human Rights if they believe their rights under the convention have been violated by their government. So, this is important. This direct access mechanism empowers individuals to hold their governments accountable, bypassing national legal systems. This is very, very important. Why? Because the individuals living in any country, they can directly approach the European Court of Human Rights, and if they are approaching the European Court of Human Rights, they can bypass their own national mechanism. So under this kind of circumstances, what happens that rights are better protected, because the national governments are also under pressure that this issue may go to the European Court of Human Rights. And then the European Court of Human Rights, it is not going to be guided by the concern like, most of the time you'll find the national courts, they are under pressure from the executive. That you will not find over here, because, it becomes a body where the people are sitting from the different countries of the world. So that way, this is one of the best mechanism of implementation of human rights that have been provided under the convention. Now, the European Court of Human Rights, located in Strasbourg, France, the court is the judicial body responsible for interpreting the convention and adjudicating individual complaints. Again, this is there. Composed of judges elected by the Parliamentary Assembly of the Council of Europe, ensuring independence from national interest. You see, the national interest is something that is most of the time quoted by the federal courts or the national courts in most of the countries. But here, what is happening? That this parochial national interest will not be quoted. Why? Because here the judges who are sitting, they are elected by the Council of Europe. And if they are being elected by, that is the Parliamentary Assembly of the Council of Europe, and they are coming from the different countries, different backgrounds. So this is the reason that the parochial, narrow national interest cannot be cited to deny the rights to a person. Then the European Court of Human Rights, you'll find, conducts a rigorous examination of complaints, examining admissibility, and if accepted, conducting hearings and assessing merits of this case. Judgments and remedies. If the court finds a violation, it issues a judgment outlining the violation and requiring the member state to provide an appropriate remedy, which may include. So the remedial measures that is provided by the court, and they may include financial compensation for damages suffered. That is one thing. So the it is part of the compensatory justice. So the financial compensation for damages suffered. Then the second one is changes in national law or practice to prevent future violations. So if the law itself, the national law or the domestic law of a country itself is such that may create situation under which law will the rights will be violated, then changes in national law or practice to prevent future violations, that can be recommended by the court. Then the third one, declaration that the violation occurred, serving as a public rebuke and pressure for change. This is also there. So a lot of pressure will be there on the national government. Supervision and follow-up. The Committee of Ministers of the Council of Europe oversees the execution of court judgments. So, it is the main executive body to look after, and that is why it sees that the judgment delivered by the European Court of Human Rights are implemented. They monitor member states' compliance, issue resolutions urging action, and ultimately initiate infringement proceedings in rare cases of non-compliance. So you can see how effective the implementation mechanism is. So a continent which is maintaining one of the best human rights cultures in the world, where the human rights are respected, democratic values are respected, and the rule of law is something that is emphasized everywhere. So that is why here, this kind of effective and powerful implementation mechanism makes people more protected so far as the rights are concerned. Regular dialogue and country-specific monitoring processes further promote implementation. Additional mechanism, friendly settlements. You see, the states and the applicants can reach out of court settle agreements before a judgment, promoting efficient resolution. This is also good, if the interstate complaint system is there or individual petition system is there. So this can be also done. Interim measures. The court can order urgent measures to prevent irreparable harm to the applicant before a final judgment. Advisory opinions. Upon request, the court can offer legal advice on human rights issues to member states. Optional protocols. That is again another significant feature of the European Convention on Human Rights. As of January, you will find that so far, today, this is not, you should not mention as of January 2010. Basically, you will find that today, what is the position in 2024 when we are sitting, that 16 optional protocols have been adopted. And these optional protocols, what they have done, they have basically amended or they have added certain articles or restructured the implementation mechanism over there. So optional, the protocol number one, this protocol contains 3 different rights, that is property, education and elections. Within the signatories, which the signatories could not agree to place in the convention itself. Civil imprisonment, free movement, expulsion, protocol 4. Some protocols we have mentioned. So you can see all the protocols, they are important. Then protocol 6, restriction of death penalty. And then you'll find protocol discrimination. Then protocol 13, complete abolition of death penalty. So that is why some articles of the convention we have already discussed, that was talking about in the exceptional circumstances you will find death penalty or capital punishment. But here what is happening, that complete abolition of death penalty by protocol 13 is there. So that is why that article should be read in the light of the complete abolition of death penalty. In conclusion, we are going to have these points. First of all, the European Convention on Human Rights stands as a powerful example of how regional human rights instruments can complement and strengthen global efforts to protect individual rights and freedoms. So you see the robust mechanism of implementation and the protection that is there. So it becomes an example for other regions and the countries. Its comprehensive framework, robust implementation mechanism, and dynamic interpretation have resulted in landmark rulings and improved lives throughout Europe. There is no doubt in it that you see the European Court of Human Rights, especially the way it is giving judgments and interpretation to the rights, that is of course improving the life of the people and also expanding the horizon of the rights. Now, key takeaways. So the European Convention on Human Rights serves as a legal framework outlining and protecting fundamental rights beyond the Universal Declaration of Human Rights. You see, it was adopted in 1950. So that is why beyond the Universal Declaration of Human Rights, at that time you will find the legally binding ICCPR and ICHR were not there. But this was conceived at that time. So that is why this is important. Individual petition rights empower individuals to hold their governments accountable. Again, states are major violators of human rights as well as protectors of human rights. So that is why this is important. Independent court ensures impartial judgments and binding enforcement. Flexible system adapts to evolving social norms through additional protocols. These additional protocols have made this convention a very dynamic, flexible, and a convention which is always ready to ready to accept the challenges, and according to the needs and circumstances, it is adding many rights in the convention. Plays a crucial role in promoting dialogue, cooperation, and a collective commitment to human rights within the European Union. So with this, we come to conclude this our lecture on the European Convention on Human Rights. Thank you very much. In the next lecture, we are going to take up the American Convention on Human Rights.